I'm Drew Stevenson. This is a lecture for my Statutory Interpretation and Regulation class, or Leg-Reg, about the case Nix v. Hedden, a quaint old Supreme Court case from 1893 that answers the question whether a tomato is a fruit or a vegetable. And our heading here is which textual meaning applies. This is a pretty famous case for statutory interpretation because it's one of our early examples of the court explaining the plain meaning of words versus technical or scientific meaning. So when there's multiple words for a word or multiple definitions for something in a statute or a code, which one should the court pick? The precise scientific term or sort of what's in common usage? So let's look at what happens in Nix v. Hedden and why this matters. So Nix was an importer who sued the customs collector of the Port of New York to recover back duties that had been paid under protest on tomatoes imported from the Caribbean. And so basically, the customs collector had assessed the tomatoes as vegetables, which carried a 10% tariff under the Tariff Act at the time. But please note that fruit did not. So there was basically, you had to pay customs or a tariff if your shipment was vegetables, but you wouldn't if they were fruit. And this person, this importer, said they shouldn't have had to pay on their boatload of tomatoes. Now, let's talk about just a policy question. This is sort of an aside before we get to the statutory interpretation question in the case. Why would the statute have said this? And I would really encourage my students, when you're interpreting statutes, before you rush into applying rules or legislative history or just trying to talk about congressional intent, ask yourself take a couple steps back question of why do we even have this question? And the answer, I think, here is that tariffs are usually designed to benefit local or national producers of a good, and that could be local farmers and agriculture, or the factories and producers, manufacturing plants inside a country that have tariffs. In other words, even though the media could give the impression that we have tariffs and trade wars to hurt other countries, usually the political pressure to impose tariffs and customs comes from the constituent group of voters who are the producer of this good and are tired of having foreign imports underprice them or cut into their profits. And at the time, in the late 1800s, American farmers, if you can think about the climate that we have here and how many states were in the Union and so forth, probably grew mostly vegetables. We didn't grow a lot of fruit in the continental United States, except for things like apples and pears that grow in colder climates. So a lot of the fruit, besides apples, were imported from warmer climates, oranges and bananas and pineapples and things like that. And so vegetable imports were competition and fruits were not, right? Again, to kind of frame this for you, if you grow broccoli, let's say, or beans or something like that, or corn, and someone overseas is also growing that and can grow it cheaper, then that cuts into your profits. But if you have no way of growing oranges and pineapples, then you don't mind if those get imported because they don't cut into your profits or compete with your business. And so this is a little bit of conjecture, but just to understand a little bit of the politics and policy that probably brought us to the question that we have in this case. Now, Nix argued that the tomatoes actually should have been assessed as fruit, which would have carried no tariff, because tomatoes, technically, from a biological standpoint or botanical standpoint, are the fruit of the plant. And the Tariff Act actually did not define vegetables and fruit. So we don't have a statutory definition here. And the court needed to determine whether the technical, like scientific, or ordinary meanings of the terms were most appropriate. The court, if you read the opinion, goes through the definition of fruit and vegetables and tomatoes in a number of dictionaries, acknowledging that from a scientific or botanical or biological perspective, tomatoes are fruits, or I've also heard people argue that they're technically berries. And but the court then turns to the common understanding of the character of a tomato, and actually um, it goes into a digression about how it's eaten in American culture as a vegetable with the main course or in a sauce or something, and not as a fruit or a dessert. I always chuckle when I get to this part of the case because we all have stories about getting used to our in-laws when we first meet our spouse. And one of my things I had to get used to was my in-laws would, after dinner, when they were eating at home, would bring out slices of big tomatoes and put sugar on them and eat them as dessert. So I think about that every time I hear the US Supreme Court saying that's wrong. But uh, going back to our case here, so tomatoes scientifically are a fruit, right? So you can't really argue with a botanist about this, but they're commonly treated as a vegetable. So the court concluded that the layperson's definition should be more appropriate here. And also, I want you to notice they don't really try to answer it from the standpoint of, let's say, competition and American growers, which was the real policy impetus behind the tariffs in the first place. And that's a curiosity about the case, besides the sort of funny thing that they're answering this, trying to answer this question legally instead of scientifically. But a modern court might have looked to the intent of Congress, which is to protect American growers, and then asked, well, are American growers growing tomatoes, which they probably were. And so note that this has significant financial consequences for importers. So the court's not just doing a party trick here or answering an arcane question for fun. This actually is money out of pocket for the importers. On the other hand, conversely, it brings in more revenue in customs for the government and benefits local growers. Here's for those of you who like to highlight in your casebook, here's a quote I pulled out for you. There being no evidence that the words fruit and vegetable have acquired any special meaning in trade or commerce, they must receive their ordinary meaning. And in other words, the court concedes that special trade terminology and jargon can be a statute's meaning, but there is no evidence here that importers call tomatoes fruit. And I want to say something about this for my students. You may remember maybe in your first year torts class when you learned about liability, that sometimes courts will recognize an industry standard in terms of for something like safety or a duty of care. If within an industry there's a certain accepted practice or sort of conventional precautions that the industry takes, those can be expected then of everybody in the industry. And we have something analogous, only analogous, in statutory interpretation, where sometimes courts will recognize that there are terms of art within industries where there's a certain word that is used a certain way commercially or in a certain trade that's different from common parlance, just like lawyers have words like consideration that have a technical meaning for us that's different from, let's say, the vernacular or colloquial meaning. And so that's part of what the court, Nix was trying to argue here, is the scientific meaning, sort of trying to fit that into the whole of a trade meaning. But there was no evidence in the case that importers, agricultural importers or food importers, were calling this fruit. So the fact that there's a technical or scientific definition is not the same as trade usage or accepted jargon or something like that. And don't make sure that you don't conflate them in your mind. And that's part of the real takeaway from this case. Okay, there's a little introduction here to using dictionaries, right? And Keep in mind that dictionaries are aids to the memory and understanding of the court, but they're not evidence in and of themselves. In the modern era, especially after a case we called Chevron, the Supreme Court started using dictionaries more and more, or with the rise of modern textualism, there was this sort of implied understanding that you could figure out what a statute meant by looking up the word in a dictionary. But note that the court here in 1893 is skeptical about dictionaries and sort of sees them as something to help you remember what a word means, or they're useful. A court can refer to them, but they can't really be the basis for resolving a case, according to the court here. And again, that's not necessarily the position of modern courts about dictionaries, but you should be aware that dictionaries play a sort of funny role in statutory interpretation. So where there is no evidence of a special meaning of a term in trade or commerce, the common understanding of a term's meaning controls. In other words, our sort of everyday usage or colloquial usage, not necessarily a word that you pull out of a dictionary. Here's a review question to see if you've been paying attention. The strongest evidence of a term's meaning when not defined within the text of the law is A, the definition most broadly accepted within the scientific community, or B, the common understanding and everyday usage of the term. Hopefully this is an easy question, and if not, you might have stopped paying attention during the video and should rewatch it. And that concludes our lecture about Nix v. Hedden.